Hello and welcome to our YouTube channel. I'm attorney Kelly Longtin, founder of Kelly Longtin Law. And today we're going to talk about whether or not your guardian for your children has to be a United States citizen. Now, one of the most uncomfortable aspects of estate planning is deciding what will happen to your child if both you and your child's other legal parent were to die unexpectedly. Now, while the odds of this happening are pretty low, the consequences of not naming a legal guardian in your will or a separate document can be pretty significant, since a court would have to choose somebody to care for your child without any input from you. Now, in our globalized and mobile world that we have now, it's not uncommon to have close friends and family members who live in a different country. Now, some of these individuals may be a good choice as a guardian for your minor child, but it does raise the question of whether a non-U.S. citizen may legally qualify for guardianship. The short answer is that your child's guardian does not necessarily have to be a U.S. citizen or a permanent resident. However, it is ultimately up to the court to approve a guardian. Now, when deciding whether to approve the individual that you nominate for guardianship, the court looks at several factors, including the individual's residency or citizenship status. A person who is not legally permitted to live in the United States may not be automatically dismissed by the court if they're otherwise a strong guardian candidate. But if that person is also named as your child's trustee, there could be some significant tax complications. So let's talk about how guardianship works. As a parent, you are legally responsible for supporting your child until they reach the age of 18. This means ensuring that they receive medical care, education, food, housing, and clothing. If you were to unexpectedly die or become incapacitated, somebody needs to step in and fulfill your parental duties. Now, normally this would be your child's other legal parent, but maybe the other parent is not able to step up because they are deceased or unable just to care for themselves. There is also the possibility, no matter how remote, that you and your child's other legal parent will both die or suffer a disability at the same time or within a short period of time. So what happens to your child then? Who will provide the care that you're no longer able to provide? Now, the adult who steps into your shoes in this situation is known as your child's guardian. Somebody like a grandparent, a sibling, or a close friend might be a good choice to fulfill this role for you and your family. Now, ideally, it should be somebody that you trust to raise your child the way that you would want them to be raised and who is willing and able to do the job. Now, parents should name a guardian or ideally a list of several potential guardians in case your first choice doesn't work out for you. And you should name this in your estate plan. Now, surprisingly, around 60% of Americans do not have a basic will, let alone a detailed estate plan in place. But without written instructions about who should care for your child in your place, that matter is definitely going to be left up to the state in which you live. Now, the court could choose a guardian for your child. If nobody in your family is willing or available, then that child might even end up in the foster care system, which is something that could most likely be avoided if you just plan for these things ahead of time. But it is important to note that even if you have a will and name a guardian, it is still ultimately up to the court to decide if that person is qualified to serve in that role. In other words, the guardian named in your will is just a candidate. A family member could challenge your nomination in court and attempt to install an alternative, or the court may decide on its own that a guardian may be unqualified. Now, it's important to note that non-U.S. citizens are not necessarily disqualified from guardianship. When evaluating a guardian candidate, the court assesses whether they meet guardianship qualifications under state law. And these qualifications typically include a person's age, their criminal record, their lifestyle, physical and mental capabilities, their financial situation, and these guidelines or criteria do vary from state to state. Now, the court will consider the best interest of the child when appointing a guardian. So nominating somebody who does not have a lawful U.S. status or who lives outside of the country could just raise some questions by the court. So they would want to know, is the guardian taking the child outside of the country to live? And if so, is that country a safe and suitable location for the child? What will the legal status of the child be in the new country, and how will that impact them? Does the child have ties with that country? Do they speak the language? Have they visited before? Are there family members over there? Is the non-U.S. citizen guardian able to travel to the United States and remain in the country for the guardianship process? Or are there any legal issues that might impede that? Another question I'll ask is, could the guardian move permanently to the U.S. and gain lawful status to remain here and raise the child? So a lot of these things will be looked at by the courts in deciding whether or not this person meets the guardian criteria. Now, as a parent, appointing a guardian is among the most important decisions that you'll ever make. So before making that decision, you do want to make sure that you talk with an experienced estate planning attorney that focuses on guardianships and conservatorships and who can help you understand options and issues that may not have occurred to you and that you're just not aware of. Now, if you decide to choose a non-U.S. citizen as your child's guardian, then an attorney can advise you about factors to consider and help you identify at least one U.S.-based alternate in case your first choice just doesn't work out. So we recommend reviewing your guardianship wishes and your estate plan in general every few years, just to make sure that it still makes sense to you, especially if there's a major event that happens in your life. So I hope you found this helpful. If you need additional help, I would contact a qualified estate planning attorney in the state in which you live. And I want to thank you for watching. If you want to learn more about estate planning, please like and subscribe to our page. I'm Attorney Kelly Longtin from Kelly Longtin Law.